We'll call this meeting to order. We have a few bills on our agenda today. Senate Bill 365 and Senate Bill 364, both by Senator Jesse Stone, Chairman Jesse Stone. And if you would, please give your attention to Senator Stone and Thomas Worthy from the State Bar and the Criminal Justice Reform Council. Senator Stone.
Thank you, Mr. Chairman. SB 365, the first one that was taken up by subcommittee is the reentry bill, and also the bill that brings some juvenile procedures in compliance with what's required to access certain funds from the federal government. Section 1 of the original bill has been deleted in the current LC, which is LC 29-6000.
We're going to go from
I'm sorry.
LC 29-6044S.
Oh, that's right.
I think that's the one that passed out of subcommittee.
Yeah, that's right. Excuse me. So Section 1 has been taken out. That was a provision dealing with record restriction and third-party or reporting agencies and their limitations on reporting. That is being taken back up by the Criminal Justice Reform Council to iron out some issues raised in the to the implementation of that. That will still be an area of discussion, but it's not in the substitute.
And could I just interrupt you just a second, Senator Stone? I think some of the issues that were present in the Section 1 of the formal bill, the reason that had to be taken out is because you have reporting agencies that it would have made impossible for them to comply with the law. We're going to try to work through the issues related to that so that we can make it so that business can be done, but we won't be causing severe problems in that area.
Right. That's correct, Mr. Chairman. GCIC access to that source of information, which was a key to the original Section 1, has some limitations, and that they have to be dealt with. The other provisions that deal with reentry are they're renumbered now, 5, 6, and 7. 6 deals with the expanded authority of courts to restore driver's licenses. Under the bill from last year, only drug and mental health court divisions could do that. This is needed because persons who are coming out of the correctional system need to have transportation to find work. This expands it to all other court divisions, not just limited to drug and mental health, but has an important limitation that the conviction cannot have been directly related to operating a motor vehicle. Could apply to drug convictions. Quite often those lead to loss of driver's licenses and other situations, but not if you were operating a vehicle as a part of that conviction. Section 7 deals with the Board of Corrections directive to implement programs to assist reentry, a wide range of programs, educational, mentoring, social, behavioral, drug abuse, financial planning, what other assistance is available outside. These are all things that they're directed to implement programs. And we had testimony that they could do that gradually and that they, with their existing personnel, and that there may be future requests for funds as needed. That leads to a program and treatment completion certificate, which has an important role to play in reentry. If you successfully complete whatever program the corrections have set forth, you get the certificate unless you are one of those who have been convicted of a serious violent felony.
I guess I need to turn it up.
Also, in determining whether you receive a certificate, your disciplinary record while incarcerated and other factors deemed relevant can be considered. That leads to Section 7, the last section of the substantive provisions. And that certificate that was created in Section 6 can be used by persons who deal with ex-offenders, primarily employers, but not necessarily limited, and how it incentivizes, say, an employer to hire an ex-offender is that it creates a rebuttable presumption of due care in hiring or in other areas of dealing with offenders, ex-offenders, licensing, leasing, admission to schools, and other programs. However, this protection is not all-encompassing. It can be rebutted by evidence that extends beyond whatever the scope of that particular certificate is. Now, both Sections 6 and 7 have sovereign immunity provisions intended to protect the state from suit as a result of either coming up with the program, the certificate, or its or using it, relying upon it. Now, that leads to sections that are now 1, 2, 3, and 4. They all deal with juvenile justice. The first section requires courts to determine whether defendants should be removed from a home and also whether reasonable efforts have been made to avoid removal. There has to be a determination made as to those issues. The next section deals with calculating the time spent, deemed to be spent in foster care. The third section deals with requiring DJJ to make administrative reports every 6 months, while for any child that has been committed to custody. And the final section requires DJJ to submit a permanency plan every 12 months, and the court is to review the permanency plan within 12 months of the juvenile going into foster care status. And that review of the permanency plan, which is designed to assure that a child quickly attains substitute long-term housing, notice of that is given to parents, guardians, legal custodians, attorneys, and any other relatives that are providing care for the child. These are all designed to allow the state to draw down funding under Section 4E of the Social Security Act. And that covers, in summary, the SB 365. I have Mr. Thomas.
Mr. Chairman, members of the committee, thank you very much for this opportunity. I will be very brief. Chairman Stone outlined all the substantive pieces of this bill. As a co-chair of the Criminal Justice Reform Council, I wanted to give you a little bit of background on the council, how it was set up and divided up, and where this came from. The council had two substantial working groups. One was the reentry working group, and one was oversight and implementation working group. The oversight and implementation group is supposed to look back on past reforms, make sure that the data is meeting where the legislature and the governor's expectation is, collecting that data and making recommendations to clean up previous reforms. And then the reentry work group actually debated and discussed the policy proposals contained herein. The only other thing I wanted to add about 365 is the reason that you see the juvenile justice Title 4E drawdown language in here and not in 364 is because the Criminal Justice Reform Council of report of 2012, so not this past report, but the report prior to, asked the Department of Juvenile Justice to look and to tell us what they can do to maximize Title 4E drawdown for children in their care, and they came back and reported to our council this year what needs to happen. And those sections 1, 2, 3, and 4 are exactly that. The juvenile court judges are well aware of it and support those provisions, even though you're tweaking slightly what has to be contained in their orders.
Any questions of the presenters? Seeing none, is there anyone here to present on the bill other than Senator Stone and Mr. Worthy? All right. I'll entertain a motion. Is there a second? Okay. This is, there's a motion due pass on Senate Bill 365, LC 296044S. Yes. All right. Any discussion on the motion? Was there any? Okay. All right. Seeing none, Chair calls a question. All those in favor of the passage of Senate Bill 365 by committee substitute LC 296044S say aye. All those opposed vote no, or say no. Passes unanimous. All right. Now, Senator Stone would like to take up Senate Bill 364, LC 296040 ECS.
Thank you, Mr. Chairman.
Is that right?
SB 364 is a bill that resulted from a process that occurred in the interim between when we enacted HB 242 last year, that was juvenile code reform, and when the provisions went into effect. Stakeholders in the juvenile justice process, including the judges, attorneys, CASA volunteers, and others, had the opportunity to more fully review the bill, and acting in coordination with the Criminal Justice Reform Council, suggestions were made to correct terminology, grammatical errors and mistakes, cross-references, and to better align Georgia law with relevant federal law and improve consistency of language within the juvenile code. So that is the thrust of Part 1 of 364. A lot of this is procedural, bringing the procedures in line with the substantive changes that were made last year. Section 2 goes back before the to the previous year's criminal justice reform, and addresses some issues that were made aware primarily in the area of controlled substances. And here we refined the definition of controlled substances, excuse me, and in the substitute that has been further refined, changing the definition or broadening the definition so that a solid controlled substance is anything that's not a liquid or a gas, and then adds to the list of examples two additional items in addition to pills and other typical solid forms of controlled substances. We went into a fairly detailed discussion of some of the procedures that were refined in the Part 1, but I'll be happy to answer it or attempt to answer any questions the committee may have regarding either Parts 1 or 2.
I don't see any questions at this time. Does anybody have any questions of presenters? All right. Then I will entertain a motion. I hear a second. By ECS. Okay. Okay. Is there any discussion on the motion to do pass? Seeing none, Chair calls the question. I'm sorry, Judge Goslin, I just saw you out there, and I wish, where's Roger Lane when I need him? But the chair calls the question. All those in favor of passage of the bill, of the Senate Bill 364, LC number 296040 ECS, indicate by saying aye. All those opposed, no. Pass unanimous.
Thank you, Mr. Chairman.
Thank you.
And I
Thank you.
believe is Rick Gold, I think, is carrying it.
Mr. Golick's carrying.
I believe Mr. Golick's carrying 365, and you are carrying 364.
Oh, I gotcha. I got that one.
Thank you.
Okay, thank you very much. This meeting is adjourned. Thank you. Okay, let's get this done.
Yep.